Hello, everybody. To start the class, I want to go through the Occupational Safety and Health Act of 1970. This is really important to go over and to understand because this is really what sets up the base not only for the 1910 series that we're going to go about, or that we're going to go through on this semester, but really the entire safety field and all of occupational safety comes down to this one act. And if we have a good understanding of this act, then we're able to understand the rationale behind some of the laws or the standards and how best to comply with them. So I guess to start off with a little bit of background to the Act. And the way a lot of people refer to this, like you see up on the top, is OSHAct, Occupational Safety and Health Act. It's just OSHAct, and that's how I'm going to refer to it as well. So this was actually sponsored back in 1969, 1970 by a couple of congressmen, Representative O'Hara from Michigan and Senator Williams from New Jersey. This is actually, I guess you'd call the second kick at the can for some sort of occupational safety and health regulation. It started off in the Johnson administration. It never really took root. Came back around in the Nixon administration, and then it actually took root and grew from there. Surprising, especially if you look at today's political environment, it had pretty wide bipartisan support. Everybody could seem to agree with the fact that, you know what, the safety of our people is good. It's an important thing. There are some little things. Republicans wanted that independent safety and health research agency. We call it now NIOSH. And Democrats wanted to make sure that there was included a general clause so that it was to say that employers had to keep their people safe, and then had the right for union representatives to accompany federal inspectors. This bill was signed on December 29th, 1970, and OSHA actually came about April 28th, 1971. And then this was amended in January 1st, 2004 as well, the actual OSHAct was. So if you look at the OSHAct, and I have this on your on the Blackboard page, you should read it. I mean, you're going to have a quiz, and it's going to be based off of that, not necessarily what I'm covering here. There's 34 sections, although there's some that have been removed. If you look at the end of the Act, there's some things. Let me take a look here. Economic assistance to small businesses was taken out. Additional assistance to Secretary of Labor. Emergency locator beacons. Just stuff that really didn't apply anymore. So some of those have been removed. But what the OSHAct really does is it sets the ground rules for safety. That no matter where you're at, no matter what you're doing, there's certain things that you just have to do to protect your employees. And the first one is going to be Section 5. And the really important, and probably the most important thing for this entire week is this right here, Section 5, especially the 5A1. This is that general duty that I was talking about. And this is something you're going to have to know, and chances are you're going to need to memorize it either through the program or through your safety career. And it's 5A1 is that each employer shall furnish each of his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause serious physical harm to his employees. Now, of course, this is a law, so every part of that has been taken to court one time or another. What really this says is if you know that there's a hazardous situation, or you should know that there's a hazardous situation, you need to protect against that. So, for example, there's some places that say, you know what, we've never had this issue, so we're not going to worry about it. But it's a common issue throughout the entire industry. Well, at that point, they should have known about that, and they're going to have to protect their employees. There is one other part of Section 5, and that is 5B. And this is the one where it says employees have to comply. So you have 5A, which talks about the employers. Then you have 5B, which talks about the employees, saying, you know what? Not only do you have to follow the rules, but you have to follow the standard, the actual laws that OSHA has passed. But you have to follow your employer rules as well. So if you have somebody saying, well, show me in the OSHA book where it says that, it doesn't really matter. If the employer said you have to wear this piece of personal protective equipment, you have to use it. Now, that being said, it's rarely, if ever, cited. I don't even know of a case where an employee has been cited under 5B. What it is used for more than anything else is as a defense. So, for example, you have an employee not wearing safety glasses. During a compliance inspection, OSHA sees that the person is not wearing safety glasses. And then you can go back and say, look, we have talked to this person. We have written them up. We've done additional training. We've done all of these things. They're still not doing it. And at that point, you may be able to get out of a citation that way. This is also used for discrimination or whistleblowing, to say, you know what, we've done all of this stuff and this person still doesn't get it, so we're just going to have to let them go. So if we get into Section 6, Section 6 is where the Department of Labor and OSHA, by extension, has the right to develop standards. Now you got to remember, this is federal law, so if it's not specifically written out in this law, they can't do it. In fact, we'll talk about warrants a little later when we start talking about inspections. So it has the right to set up these standards, and exactly what needs to do. You have to have so much public hearing, you have to give so much notice, etc., etc. One of the things it does do is it gives the right to employers to request a temporary order or relief for up to 180 days. So, for example, there's been some stuff in the safety news lately as far as different standards. It comes back a couple of years, but confined spacing instruction, we have this new thing. I work for a construction company. I have areas where, you know what, I physically cannot do maybe what they're saying we need to do. They can turn around and request relief for 180 days to give them a chance to engineer it out. It also, Section 6 requires rationale if the rule is different than consensus standards. So consensus standards, what they are, is like an industry standard that they figure is the best practice. Typically, these are non-enforceable. We'll get into a couple of situations where they might be. Examples would be like NFPA, the National Fire Protection Association. They have some recommendations, some consensus standards that they use. ANSI, almost all of the safety standards out there now came from ANSI in one way, shape, or form. Those are the two really, really big ones. You can still have ASTM for engineers and other things as well. Like I mentioned before, typically these are non-enforceable. They could feasibly or potentially be cited under a general duty clause if there's no other standard. So, for example, there's already a standard for safety glasses, and the safety glasses says you have to follow this version of ANSI. A compliance officer cannot come in cite, okay, well, yeah, you're complying with 2004, but now it's 2016, so you should follow the 2016. They can't do that. That being said, if there is not a standard on it, then they can absolutely come and cite that. And they can cite the general duty clauses because it's a hazard you knew or should have known about, and there's this consensus standard to say how you should comply with it. Now, I don't think it happens very often, but it's often enough to know about the consensus standards, etc. So, excuse me. Section 7, really all this does is set up the National Advisory Committee on Occupational Safety and Health, or the NAOSH. Made up of 12 members. Department of Labor, Secretary of Labor is the one, I believe, who sets those up. And out of those, there's some people from the general public. There's some representative from the labor unions, representative from management, and then OHS, or Occupational Health and Safety Professionals, which is nice, the fact that they're actually letting the professionals have a seat at the table. And basically, the role of this group is to advise OSHA on these rules or what should or should not be implemented. Section 8, it gives the Department of Labor, and again OSHA, the ability to perform inspections. A couple things with that. OSHA can come in without delay. You can't sit them in a room for 4 hours while you go and clean up the shop. They can enter without without being held up too much, and at reasonable times. Now, coming in at 2 in the morning probably is not going to fly, but there's also a section that says during normal working hours. Now notice that doesn't say during normal business hours, that's working hours. So if you regularly have people working on the third shift, legally OSHA can come and inspect them. Now, I don't hear that too often. In fact, there's been one time where I heard that they went out on a Saturday, but I never heard that anything happened beyond that. It's typically during normal hours, but that's not to say they can't. It also gives OSHA the ability to require specific records to be kept, and we'll be going through many of those in the next few weeks. And then it also requires a employee representative to be allowed to participate. Now, that doesn't mean they necessarily have to, but they have to have the right. This really comes down to workplaces that are covered under collective bargaining. If there's a union agreement in place, then the union rep is going to be the one to do it. If it's not a union situation, you may have somebody else that wants to come and participate. They can come through and do the walk around on behalf of the employees. It could even be to the point we're going to point this out, point this out, point this out. And again, that was kind of one of the compromises when the act was actually signed or written. Section 9 talks about the citations. It allows the Secretary of Labor, and if you get an OSHA citation, that's who it's coming from. It's coming from the Secretary of Labor. It gives them the right to actually assess citations for violation. These have to be in writing. It's not something that the compliance officer, as they're leaving, says, "Oh, by the way, you're going to get fined, and you can go ahead and pay me now." No, this has to be in writing, and it has to be sent out a very specific way. The other thing is all citations have to be provided within 180 days of the inspection. So it's there is a limit to it. You can't be hanging out 2, 3, 4 years and wait to get a citation in the mail. Typically, these are going to be sent certified mail. In fact, that's the only way I've heard. Take it back. I've heard one extreme case where it was actually hand delivered and signed with an affidavit. That was pretty bad. They were having a bad day when that one came, and that came at 180 days. They wanted to make sure they met that. They had a lot of willful citations, etc. It was pretty bad. But these citations are going to be in writing. They're going to be sent certified mail. With that, you do have the right to contest a citation. And the employer, they can contest anything they want. I've been part of contesting. I've won contested citations where we contested the actual standard. Said no, that's not what the standard says. That he was not doing that. This standard doesn't apply. This isn't a lockout. This is a fire or whatever. They can most commonly they are contesting the fine, trying to get the fine lower, or it may be abatement. Now it's really important, and we'll cover this a lot more when we get into safety management later in the program. But it's really important that you take advantage of this to do at least an informal contest. You go sit down in front of the area director, and you plead your case and say, this is what we're doing, this is what we've done already, and they have a lot of flexibility on what they're going to do. So it's really important. If you don't like it, you can always contest it, and that becomes a formal contest, and then it goes in front of lawyers and stuff like that. Once you go beyond that point, then there's legal fees and such like that involved. It's not something that even a good consultant would probably not want to be involved if you're formally contesting the citation. Employees can participate in this, but the only thing that they can contest is the abatement date. This usually what usually happens here is the employer says, "Oh, well, we can't possibly fix that for 9 months," and the employee comes in and says, "Oh yeah, you can. We can do this, this, and this, and we can do a workaround, and we can do it, and we can at least comply." So that's kind of how the contesting abatement dates work. So if you look at the life of a citation, first of all, you have your inspection, and then you get your citation, and that has to be sent within certified mail within 180 days. You have 15 days to contest the citation, and during that time, it's usually I want to come in and talk to you. Let's talk about this. Let's lay our cards on the table and go from there. That has to be done within 15 working days of receipt. So if you go back to the first one, certified mail, one of the things you have to do is you have to sign the card saying you received it. And then you have 15 working days. So it doesn't include Sundays, may or may not include Saturdays, not sure. But you have 15 days. Now, once that 15 days are up, you're done. It's final. You have to apply. You have to agree or comply with any abatement. You have to pay whatever fines, whatever it is. It has to be done. So one of the things that's come up in the past is the mail person is on vacation or the safety person's on vacation. I sign this card, and all of a sudden I get back, or the safety person gets back, and there's this citation that nobody's looked at for 2 weeks, or 3 weeks, and all of a sudden you're overdue. You're stuck. So your mailroom staff, they have to be trained that if you get that citation, somebody needs to know about it right then and there. So if you do contest the citation, next it goes in front of an administrative law judge, and this is a court proceeding. Saying, okay, here's our cases. Here's what we disagree with them. This is why. If you disagree with the administrative law judge, you can appeal it up to the review commission. The commission is a group of 3 lawyers that basically go through and say, yep, nope, we agree with what OSHA did. Nope, we don't agree with them. They are nominated by the president and confirmed by the Senate. So if you disagree with them, you can appeal it to the U.S. Court of Appeals. And if you disagree with that, you can appeal it to the Supreme Court. Now, if you notice, this is a lengthy process, and considering the legal fees that are required, this could get very, very, very expensive as well. So, what happens a lot of times, they'll go through it for an informal, get some stuff changed, and then it ends with that, because companies will spend more on contesting a citation than they ever would have for the actual fine itself. Section 15 talks about privacy of trade secrets. Now, you can imagine there are a lot of companies out there with very specialized processes that they don't want the whole world to know about. So what this section does is this requires that if OSHA goes into a facility and they're told we have a trade secret here, they have to protect that. Things like this can't be open to open records requests or Freedom of Information Act, because they want to make sure that companies aren't necessarily going to be hiding their sections of the plan. Penalties. This section 17 is what set penalties for OSHA citations. This was changed in August 2016. It just went into effect. So basically, there's 3 big categories of of site violations. The first is serious, other than serious, and posting requirements. The old requirement was $7,000. That's what would be in your book. This just went up to $12,471, and this has to go up with the cost of inflation. So this is going to go up higher and higher and higher. Failure to abate. So you've said, okay, this is what we're going to do, or you've been ordered by OSHA, this is what we have to do to fix it. You don't. The new citation is $12,471 per day per violation. So if it's been 30 days, you take that or 10 days, just because the math is easier, they can cite you for up to $124,000. If it's 20 days, up to $248,000. You can see how this can add up very, very, very quickly. And the last one is the willful and the repeat violations. These are the big ones. These are where there's just plain indifference, or you've been cited once and you didn't learn your lesson. So they're gonna cite you again. They're gonna throw an extra 0 at the end. These violations are $124,700 is the maximum amount. So these have went up dramatically. And now it's to the point where employers are starting to notice, you know what, we don't necessarily want to pay a $124,000 citation. $7,000, yeah, we'll absorb that, but they're raising these to the point to make it a little bit more of an incentive to be compliant. Last thing I want to talk about is sections 20 and 22. They're kind of really together. Section 20 established the National Institute for Occupational Safety and Health, NIOSH, and then section 22 kind of dug in a little bit deeper. What NIOSH is the research arm of safety. So you have kind of two agencies, and they're really designed to be like sister agencies, where NIOSH came up with the best practices, and OSHA came up with the standards, and OSHA did the citation, and NIOSH did all the training and all that. It's kind of fallen on the wayside. Really now there's OSHA with the Undersecretary of Labor in charge of OSHA. Right now it's Dr. Michaels. He's going to be ending his term fairly quick. He knows the Secretary of Labor. They probably have lunch once a week and talk. Well, if you look at NIOSH, NIOSH is kind of buried. Technically, by law, they fall under the Department of Health and Human Services. And they're even further underneath there. They're under the CDC. So the director of NIOSH, he probably knows who he is, the Secretary of Health and Human Services. Probably knows who it is, but they're not really that close. They don't work that closely together. And that's one of the shames of how this really happened versus how it was designed. So that is really all I have for this first week. So make sure you check Blackboard and look at whatever assignments, tests, quizzes, anything else that needs to be done. And if you have any questions, please get a hold of me.